Okay, I'd like to thank everybody for joining us here today for a very important session that we're going to have. This is the New York City Russia Public Policy seminar series that is jointly sponsored by the Harriman Institute at Columbia and by the Jordan Center for the Advanced Study of Russia at NYU. My name is Joshua Tucker. I'm the director of the Jordan Center for the Advanced Study of Russia at NYU. I'm joined by Elise Giuliano from the Harriman Institute here. We'll be co-hosting, co-moderating today's session. The New York City Russia Public Policy Series is generously supported by funding from the Carnegie Corporation of New York. We've been doing this for about 5 or 6 years now. It started off in person and it went fully online during the pandemic, and we've kept it in this virtual format since then. The series meets once a month during the academic year. You can check out and see what's coming next at both the calendars at the Harriman Institute and at the Jordan Center, and I believe our next meeting is scheduled for November 11th. Just to give you a quick preview into the format of how this is happening, at this point, everyone I think is pretty familiar with Zoom webinars, but we have 4 esteemed panelists here today to talk to us in what I'm sure is going to be an incredibly enlightening session. They will each give opening remarks of about 10 minutes or so. That will then be followed by a question and answer period. And you can use the Q&A button below on the webinar to leave your questions. One of the nice things about the webinar format is that you can leave questions while the panelists are speaking. It won't interrupt them at all. We will address the questions afterwards, so you can jot down your questions as you have them while they're speaking, or you can wait till the end and add questions after all the panelists have had a chance to speak, and you can continue adding questions at any time you would like. For those of you who are joining us on YouTube, you should also feel free to use the chat function in YouTube to ask questions if you would like as well, and we'll try to keep an eye on those also. So without further ado, I'm going to turn it over to Elise Giuliano to introduce our panelists here today. Elise?
Thank you, Josh, and thank you everyone for attending what I think is going to be a very important discussion today. I would like to extend a warm welcome to our speakers. And they are Rachel Denver, who is Deputy Director of Europe and Central Asia Division at Human Rights Watch. And then we will hear from Nathaniel Raymond, who is the Executive Director of the Humanitarian Research Lab at the Yale School of Public Health and a lecturer in the Department of Epidemiology of Microbial Diseases at Yale. Then we will hear from Monica Nalepa, who is a Professor of Political Science at the University of Chicago. And finally, we will hear opening comments from Scott Strauss, who is a Professor of Political Science at University of California, Berkeley, and the 2023 Mahatma Gandhi Fellow of the American Academy of Political and Social Science. I would just like to say a quick word about this panel. We want to acknowledge the very important work being done by Ukrainian colleagues in the sphere of researching human rights abuses and war crimes connected to Russia's war in Ukraine. And I want to also mention that Harriman Institute has some ongoing programs with such scholars and activists from Ukraine. And we also host them in other talks and panels. So if you're interested in learning more directly from Ukrainians who are involved on the ground there, please sign up. You can see in the chat, there's a link. You can please sign up for Harriman Institute mailing list, and you'll hear about many more panels, talks, and events. And with that, I will turn it over to our first speaker, Rachel Denver of Human Rights Watch. Rachel?
Sorry. Thank you, Elise. It's wonderful to be in this esteemed panel, and it's always a pleasure to be speaking to colleagues from the Harriman Institute, of which I am an alumna, together with NYU. So Human Rights Watch is a international human rights organization. I think many of you know we work in more than 90 countries around the world. We've been working on Ukraine since before the breakup of the Soviet Union. And obviously we've been working on documenting violations of international humanitarian law in the war in Ukraine since it started in 2014. So I think before I talk about the types of violations that we have been documenting, I think it's important to just reiterate that our legal framework for our work in Ukraine today on the war is international humanitarian law, which without getting too geeky, I'll just say is, and maybe there are other people who will address this more extensively. So our lens is the Geneva Conventions, the 4 Geneva Conventions and their additional protocols, that govern the rules of armed conflict in international armed conflicts. So, for which the principle, the main guiding principle is the protection of civilians from the harms of war, and which obligate all parties to an armed conflict to take these steps, regardless of whether they regardless of whether they were attacked or whether they are the attacker. So with that, let me just say a couple of words about the types of violations that we've been documenting, how well documented they are, what some of the challenges are. So really that's we have been documenting, and not just I just want to say it's not just Human Rights Watch that's been doing this work. There's been Human Rights Watch, a number of extremely skilled, highly professional Ukrainian organizations, other international organizations, I'll get to that in a second as well, that have been documenting these. It's the main pillars of violations are the widespread indiscriminate bombing and shelling in civilian areas that violate the principle of distinction, which is probably one of the key aspects of the Geneva Convention. So indiscriminate bombing and shelling, we hear about bombing and shelling of areas that are not, that are either on the front line or well beyond the front line. We hear about these attacks just about every day. Our job as a human rights organization is to figure out which ones are indiscriminate or disproportionate or indeed deliberate. And there we've done there's a lot of documentation. Human Rights Watch, a couple of the key examples I think that Human Rights Watch has published on include the Kramatorsk train station bombing that was hit by cluster munitions back in April of 2022, had a very high civilian casualties, up to possibly as many as 61, hit with like I said, with cluster munitions. I think that's we've documented the bombing of apartment building in Izium that had again a very high civilian casualty count. We documented numerous attacks in Kharkiv and Chernihiv regions, particularly in the early phases of the war. We documented the attack on the Kremenchuk shopping center that took place last year, a pretty blatant and indiscriminate attack. And more recently, there was the attack in Lviv. So there are numerous attacks, and these are just the ones that Human Rights Watch has documented. And then more broadly, there's the Russian forces campaign to bomb bomb and shell Ukrainian energy infrastructure that started last year at the end of October and then through the winter, that had the obvious aim of making life as unsustainable as possible for the civilian population. That's kind of one pillar of the violations that we've been documenting. Another pillar are the violations of, you could call it, violations that happen in areas that are under the control of Russian forces, violations of personal integrity. These are the torture, extrajudicial executions, sexual violence, arbitrary detention, and other crimes or violations of personal integrity that are perpetrated by Russian forces, by Russian occupation forces in areas that they are occupying or controlling. And there, I think one of the emblematic case was Bucha at the very beginning of the war. But it's not just Bucha; it's really we've documented these kinds of abuses really just in just about every region that Russia has been occupying, in all over Chernihiv region, in Chernihivska region, Kievska region, Khersonska region, Zaporizhzhia region, this is an area that it's obviously very, 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 very disturbing. And, you think about it every day, because there are still wide swaths of Ukrainian territory that are currently under occupation. I should also add, obviously, and also Crimea, because there are arbitrary detention, torture, forced disappearances that are taking place in Crimea. There's also the forced transfer of civilians that I believe that Nathaniel is going to talk about more, but we have documented the forced transfer of civilians from from occupied areas that Russia's occupying to other occupied areas of Ukrainian territory, and also the forced deportation of Ukrainian civilians from areas under Russian occupation to Russia. Our documentation is mostly of the forced transfer of adults, or the forced deportation of adults, and I believe Nathaniel's probably going to be talking about the forced deportation of children. We have also I think it's important to point out that forced transfer is not just the forced transfer of civilians who are sort of rounded up or intercepted at checkpoints. It's also civilians who are detained by Russian forces in areas where Russian forces are occupied. They're detained and then moved to prison facilities in Russia. That is also a forced transfer. And we're also documenting the attacks on cultural property. So and the looting of cultural property. We did some work on that in Kherson. We're looking at the imposition of the forced imposition of the Russian curriculum in schools in areas where Russia is occupying. That is also a violation of international humanitarian law, and done with an intent to erase Ukrainian identity, erase Ukrainian culture. Look, I think that's just the short list. I hope it's a fairly comprehensive list of the types of violations. These are the violations that we are documenting. There is there are many other institutions that are doing documentation. There are the Ukrainian groups that I mentioned at the beginning, including Truth Hounds and Zmina and a number of other groups. There's also the several UN agencies that are documenting these abuses. There's the UN Commission of Inquiry that has found, for example, that that torture and that torture is widespread and systematic and potentially a crime against humanity in Ukraine today by Russian forces. And also they're looking at the bombing campaign against Ukrainian energy infrastructure also as a potential crime against humanity. Of course, we also know that the ICC, the International Criminal Court, has an as an active investigation on Ukraine, and they're looking at those violations for probably that are committed for which they can establish high level accountability. So as we know, they have issued an arrest warrant for President Putin and his Children's Rights Commissioner Maria Lvova-Belova. Nathaniel will probably talking about that as well, for the forced deportation of children. And there's this extensive documentation, obviously, by the Ukrainian authorities, by the Ukrainian prosecutor's office. There are tens of thousands of cases that are currently in their docket. So the documentation is quite extensive. The methods the Human Rights Watch uses to document these abuses is a mix of the old and the new, the old-fashioned just victim interviews with survivors, witnesses, and experts, whether they're arms experts or ballistic experts and the like. So triangulating, sort of pinpointing to the degree that we can through, by interviewing multiple people of various incidents, and combining that with satellite imagery, verifying material from social media, doing digital reconstructions, for example, to help witnesses reconstruct what actually happened in certain locations. And there are other new technologies as well. What are some of the challenges? Well, it's contradictory. Like on the one hand, there is just an unimaginable scope of abuse, the full spectrum of abuses over a wide swath of territory and over a long period of time, and potentially even longer. So it's quite, I think one of the challenges is to really be able to prioritize. And on the other hand, it's also, ironically, on the other hand, another challenge is it's a very crowded space. Fortunately, there are a lot of organizations that are doing this documentation, and sometimes we really need to avoid duplication. We really need to avoid interfering with each other's investigations for our respective purposes. So, Elise, should I stop there? How am I doing on time?
Yeah, I mean, if you want to stop and we can pick it up again later during the discussion.
Why don't I stop there? I hope that we'll be able to address a little bit just what what lessons do we draw from other wars that Russia has carried out in the region. I'll just flag two things that might provoke questions. And one is that Russian forces have proven to be completely unbothered by international humanitarian law, and we know that from the past. We know that from the war in Chechnya. We know that from the war in Syria. We know that there have been limits to international. There have been limits to holding Russia to account. On the one hand, we have there's, if anything, there's an utter contempt for that the Russian authorities hold for accountability processes. Right now, the ICC, any kind of cooperation with the International Criminal Court is now criminalized in Russia. That gives you just a little taste of the contempt for which they hold accountability. On the other hand, there were hundreds of judgments at the European Court of Human Rights for Russia's actions in Chechnya, and even though they didn't change Russian conduct, they did provide, I think, an avenue for people survivors in Chechnya to feel that they got some sense of validation of that they were in fact the victims of human rights abuses in Chechnya. So I think that we shouldn't minimize the importance of that. And we can talk more about the challenges of justice more in the Q&A.
Okay, great. Thank you, Rachel, so much. Now we will turn to Nathaniel Raymond, who's the executive director of the Humanitarian Research Lab at the Yale School of Public Health, and is very well known for the work that the lab has done on the deportation of Ukrainian children to Russia. Nathaniel.
Thank you. And it's a real pleasure to be here today. And I think it's important, given all that's happening right now in Ukraine and elsewhere, such as Israel and the Palestinian territories, to talk about, and Sudan, to talk about what's happening in Ukraine, because really the headline here is that if you look at the history of international accountability for mass atrocities, gross human rights abuses, violations of the laws of armed conflict, you have sort of three pivot point events. The first, obviously, Nuremberg trials after World War II. Then you have the late 90s with the International Criminal Tribunal for former Yugoslavia and Rwanda, and the emergence of the International Criminal Court with the Rome Statute in 1998. And what's happening right now, really driven by accountability efforts in Ukraine, I would say, is the third major pivot point, if you had to pick three, in the post-World War II history of international accountability. And so that's the overall importance of this moment, this conversation. I'm going to introduce the work of the Humanitarian Research Lab at the Yale School of Public Health and talk about the sort of 6 areas that we work in Ukraine. And I'm going to start with a very technical sort of intro to how we do our work, because our role, as our colleague from Human Rights Watch said, there's a lot of different groups in the space, and it is an ecosystem where there's different technical roles, and there's also different supporting roles and relationships to different types of accountability processes and theories of change. So I just want to orient you on where Humanitarian Research Lab is and use that as a framing to talk about some of the issues, opportunities, challenges in the 6 areas that we look at right now. So what we do is we're engaged in data fusion. We don't have researchers on the ground. We have 2 big streams of data: open source information, yes, social media, yes, publicly available data about network functions, media reports, et cetera. But the other big piece in our work that's called the Conflict Observatory, which is a program of the U.S. Department of State's Bureau of Conflict Stabilization Operations, we use commercial satellite imagery, large, unprecedented amounts of commercial satellite imagery and other remote Earth orbiting sensor data to really fuse together these 2 streams to create what's called the mosaic effect, which is basically, I'm going to use some fancy terms and I'll define them: temporal, spatial, semantic, cross-corroborative differentiation, which in English means time, place, word comparison. Okay, and so we are looking at these large amounts of data to be able to identify incidents and then corroborate them. Now, we also work on Sudan, and there's, as part of the Conflict Observatory, and there's sort of 2 big posture differences here. One, our mission on Ukraine is accountability. So we are supporting International Criminal Court. We're supporting the Office of the Prosecutor General in Ukraine, and we're supporting other accountability mechanisms of a judicial nature with our report. So we're not focused in Ukraine on advocacy, and we're not focused in Ukraine on specific incidents per se. By and large, we're focused on trends and patterns of alleged criminality to be able to provide this fused data product, not instead of witnesses, but is really a platform to corroborate other types of testimony and evidence, such as witnesses, such as forensic evidence, physical remains, ballistics, site examination, et cetera. And so we're bringing a very specific type of evidentiary product to the table to support other types of evidence, not to replace it. In the case of Sudan, we're really in an early warning posture of attacks and quick documentation of incidental acts of mass atrocities and violence against civilian populations. And so it's a different purpose and a different tempo and a different approach, where we're not that we're not collecting evidence, but the real goal is civilian protection and security in Sudan versus accountability. And so it means that the reports we produce with Ukraine take weeks and months. The reports we do in Sudan can sometimes be 6 to 12 hours. And that's a very different operational tempo and very different operational requirement. Now, so the 6 areas we've worked on in Ukraine, and I'll just go through them sequentially and then talk a little tiny bit before I close about sort of the technical requirements for each of them and what their significance has been. And then I'll turn it back over. So the first area, and where we started really at the beginning of the war in 2022, is BDA. And what that stands for is bomb damage assessments on protected civilian infrastructure. So hospitals and schools. In the initial phase after the invasion, we were producing evidence for the Organization for Security and Cooperation Europe's Moscow mechanism process for documenting grave and gross abuses of human rights. And so we were looking at schools and hospitals across many oblasts for the first report, and then specifically in Severodonetsk for the second one. And what was really critical there technically is that we were able to catch a lot of imagery at what's called an off-nadir angle, which is we were dealing with saturation bombardment in urban areas. And so we were getting angled imagery of the side of buildings. One of the challenges is that there was a real lack of baseline imagery. And so now we have a lot more imagery about that type of bomb damage assessment. But in the initial phase, there was a dearth of recent imagery on those areas. And it was also winter. And so there was high cloud cover. But that was some of the first reporting on the systematic nature of the indiscriminate attacks by Russia on protected objects, hospitals, schools. Second area we really moved into is filtration. So after Mariupol fell, camps were set up to process civilians to basically assess whether they were a threat to Russia's occupying forces. And there had been reports that these facilities existed, and there had been from the United States government, including a report from the National Intelligence Council, basically a count on those facilities. What we did is got sort of the definitive number. We were able to identify well over 20 of these facilities with high confidence using the Berkeley Protocol for open source investigations, which requires 5 sources for each finding. And we additionally mapped the network by which civilians were moving with different journeys through the system, including to temporary detention and interrogation, mostly by DPR, Donetsk People's Republic forces. And then some were going to places like Olenivka, which you may have heard about, where there was the death of POWs under mysterious circumstances with an explosion, alleged explosion. We were documenting basically the systematic nature of this network and how civilians were moving through it. And it was sort of the first comprehensive view of what was happening in filtration. The third area was food security. And so we got called in to look at damage to crop storage infrastructure last summer. And we used machine vision and machine learning with our colleagues and partners at Oak Ridge National Laboratories in Tennessee to be able to do a representative sample of damage to silos and grain elevators across Ukraine, which was I can't stress how big a technical challenge this was, because we weren't just looking at one site, we were looking at over 300 sites. And so we were able to find that 14.57% of Ukraine's grain storage infrastructure had been affected, which basically corroborated the Kyiv School of Economics assessment that 15% had been affected. So we were very close. And why was that important? It was important because if there wasn't enough crop storage space, the Ukrainian farmers who could plant the winter wheat crop wouldn't have done that. And so we had to get basically an audit of the storage space of the Ukrainian agricultural sector to see how to fill that gap to prevent broad food security implications globally. And then I'll run quickly through the other areas. The thing we are known most for is our work on children. And so in February, 1 month before the ICC indictment of Vladimir Putin and Maria Lvova-Belova, we released a report on the systematic deportation and transfer. And so I just want to do a terminological difference here quickly. Deportation is moving the kids, which is a war crime, can be a crime against humanity. Transfer is moving them from one national ethnic group to another. So that's forced adoption is an example of that. And it's important to understand the first trial at Nuremberg was of the Nazis for Germanification of Polish children who were moved into forced adoption. And so that report helped catalyze the ICC indictment and led to a whole follow-on effect and focus on the urgent issue of children being moved to Russia. And we identified 6,000 that were in the camps. We know the number is significantly higher. And we really began to identify 4 groups of kids. Kids in camps, kids who were taken from facilities called evacuees, state facilities in Ukraine, kids who were taken on the battlefield, and kids who were taken infiltration. And then very quickly, to close out here, the other areas we work on is other detention settings. So we've documented mass detention, harassment, and torture, and passportization, forced nationalization of Ukrainians. And then the last point is we do incidental emergency investigations in some cases, the mass graves in Izium and the Kharkova Dam. So that's really what we do and how we do it in support of evidence for accountability. Over.
Thank you, Nathaniel. And now we will hear from Monica Nalepa, who is professor of political science at University of Chicago. Her work has a regional focus on post-communist Europe and a substantive research focus on transitional justice, parties, legislatures, and game theoretic approaches to comparative politics. Monica?
Thank you very much. And I'm very pleased to be here following presentations by Rachel and by Nathaniel, largely because I think what we're seeing is that we've made tremendous progress in documenting the committing of atrocities and violations of human rights. What I wanted to talk about is how do we bridge the gap from knowing that these atrocities happened to accountability, and also from an even broader perspective, try to see what kinds of forms of accountability ultimately lead to the reduction of repression. Because I think at the end of the day, what we care for is that these repressive acts, whether abroad or domestically, do not occur again. And my work largely concerns this. So what I'm going to focus on is talking about who to punish with this evidence that your institutions have collected, how to punish them, and will it stop repression? So first, let me start with this a question of who to punish. So since the Nuremberg trials, there's been a shift in the belief of the international community that in order to prevent repressive acts in the future, we should be focusing on those who are issuing orders, right? So the Putins, the Pinochets, et cetera. But what the study of authoritarian regimes teaches us is that authoritarian regimes are rarely centralized dictatorships where everything happens only with the permission of the leading autocrat and nothing happens without him. So a very important thing to consider in deciding how to hold accountable regimes and their members are those dynamics between leaders and agents of repression. And in some recent work that's coming out of my Transitional Justice and Democratic Stability Lab, which produces a global data set of transitional justice, what we found in a paper that I'm going to post in the chat super quickly is that for moderate levels of dependency of agents of repression on the leadership and vice versa, actually increasing the accountability of leaders for human rights violations does not necessarily lead to a reduction in repression. And conversely, increasing the accountability meted out to their agents of repression, so those who are following orders, does have that monotonic and proportional effect. So there seems to be a very widely held belief, and that belief is actually a belief that's been acted upon, that increasing accountability of those who are issuing orders through international bodies like the ICC and others is the right way to go. But at the same time, there are theoretical reasons to be skeptical about that. The second thing I wanted to talk about is how to punish those who've committed human rights violations. So it comes to no surprise for people on this panel, as well as those who are listening in, that what Putin was doing at home prior to the war in Ukraine was not necessarily popular either. He was prosecuting his citizens, increasingly encroaching on various human rights that they had, confiscating property, forcing thousands and thousands of Russians to leave home. And I'm going to venture to say that it's going to be very hard to carry out any transitional justice for war crimes committed in Ukraine without simultaneously conducting transitional justice in Russia. So this is a long way of saying that I believe that accountability for human rights violated in Ukraine, if done properly, will have to go hand in hand with regime change in Russia. And the risks of putting on the shoulders of the international community and international organizations such as the ICC the sole responsibility for holding to account the Russian leadership is the potential for a rally around the flag effect for Russians who would otherwise very gladly see their leaders and their followers punished for crimes at home and abroad. Once they see them being punished by the international community, they might simply close ranks in solidarity with them and actually defend them from this transitional justice. And we've seen this happen to some extent following the Balkan Wars in Serbia. And we know also from the work that my lab has conducted that the most effective long-term transitional justice is actually domestic transitional justice. Now, I know already that probably people are going to be saying, how is Russia supposed to be conducting domestic transitional justice if it still has an authoritarian regime in place? I absolutely see that point and concede it. Having a functioning democracy is an indispensable, a necessary condition for conducting transitional justice. But I want to also talk about alternative to criminal forms of accountability, ways of holding politicians, leaders, and their collaborators for human rights violations. So we know that criminal accountability draws enormous resources. It requires trained judges, it requires trained prosecutors. So even though we have, thanks to your organizations, Rachel and Nathaniel, amassed huge amounts of evidence, still organizing this evidence and actually carrying out a criminal trial requires enormous resources. And that is why in other cases of transitional justice around the world, what we see is actually a large degree of reliance on non-criminal forms of transitional justice, such as purges, such as lustrations, such as truth commissions. And this is the work that I've devoted to the last 2 decades of my academic career to. And there's actually a lot of evidence that particularly transparency regimes, so truth commissions and lustrations, are much more promising for long-term democratic stability than punitive forms of transitional justice for several reasons. The first one is that they do not require adherence to these very strict principles of rule of law that any criminal court case would requires us to adhere to. And second, because they can reach much deeper into the population. So in other words, they allow us to precisely hold accountable not only leaders, those who are issuing orders and telling people what to do, but also those who are carrying out human rights violations with their own hands, or those who are collaborating with those who can then carry out those human rights violations. So I think in so generally in public opinion, and in just the way that people are talking about holding Russia accountable for human rights violations, what is often neglected is this vast spectrum of mechanisms and tools that are available to us and that have been used in other parts of the world to minimize the occurrence of human rights violations committed in the future that don't necessarily rely on the criminal process. And I'm sure that Professor Strauss will talk more about the challenges of holding international criminal trials and so on. So let me just end by by punctuating why it is important to sort of to not be discouraged by the difficulty of conducting criminal trials and refuse to carry out any transitional justice at all. The first countries that transitioned to democracy as part of the third wave of democratic transitions, Spain and Portugal were especially Spain was an instance where there was a wide belief following the Civil War and then the Franquist regime that trying to deal with the past and holding accountable people for various human rights violations committed on both sides is going to jeopardize the future democratic prospects. So there was this pact of forgiveness that was agreed upon by both sides. And for almost 3 decades, nobody would touch talking about the past. This turned out to be a mistake. So following civil wars and following atrocities committed by authoritarian regimes, we no longer have the luxury of removing elites who are responsible for those atrocities into exile somewhere, so that their presence does not obstruct the building of the new democratic regime. Those elites remain, their collaborators permeate society, and their presence is, if undealt with, is a permanent threat to the stability of the new democracy. And time again, countries around the world have seen that doing nothing with regard to transitional justice, in the worst event, it can lead to victorious justice or spontaneous acts of accountability. But even in the best case scenario, it can resurface later in the form of ghosts of the past. So I will stop there because I realize that we are, I think, a little bit over time.
Thank you, Monica. That's really, really fascinating. Okay, now I am pleased to introduce Scott Strauss, who is professor of political science at the University of California, Berkeley. He studies political violence, genocide, human rights, and post-conflict politics with an empirical focus on sub-Saharan Africa. Scott?
Hi, good morning, at least from California time, and thanks so much for the invitation to join this esteemed panel. I thought I would offer some comparative perspective as I'm not a scholar of Eastern Europe, and try to situate a couple debates. And I want to emphasize that I'm speaking, from a position of humility. I'm not suffering from, bombing in Ukraine right now, and I want to just at least honor the difficulty of that war. So the two questions I wanted to address is, the first is the so-called genocide debate, and kind of thinking about why there has been so much controversy over this debate, and providing some insight into that. And then the second issue that I want to address is whether and how the war in Ukraine and the response to it indicates a weakening of the anti-atrocity regime that has been developed over the last 2 decades, or a continuation of the status quo, or I think, as Nathaniel was suggesting, potentially a strengthening of it. And I wanted to address those issues. So the genocide debate, I think, as many people probably in this Zoom room will know, is that has been, the term genocide has been invoked by both sides, by Russia in the beginning, claiming that its invasion was motivated by protecting ethnic Russians from genocide. Government of Ukraine countered, saying that was an abusive use of the Genocide Convention, and argued that, of course, that Russia was committing genocide in Ukraine. Ukraine went on to file a case that's ongoing at the International Court of Justice invoking the Genocide Convention, and there's been a number of important rulings there. Since then, I would say, from Zelensky on down, that Russia has been committing genocide has been a common refrain of Ukrainian officials. And that's been endorsed by a number of scholars and commentators of the likes of Tim Snyder and Philip Gorovich and many others, right? At the same time, there's a UN Commission of Inquiry, and in a number of different ongoing updates to their investigation, there have been, the heads of that Commission of Inquiry have said, we have evidence of crimes against humanity, we have evidence of war crimes, but we're not, we don't have clear evidence of genocide, right? So what's going on here? Why is there this debate, and sort of what's at stake? So first of all, I would say that these kinds of debates over the use of the term genocide are extremely common in ongoing atrocity environments, ongoing wartime environments. I'm sure we will begin to hear them, if we haven't already, in relationship to the war in Israel and Gaza. And I think my objective is to provide some insight into why they happen. And so I think part of the answer is that there are conflicting objectives in the use of the term genocide and the concept itself, right? On the one hand, this concept has a strong normative connotation, right? It is a mechanism to impugn your opponent and to highlight the victimization of your own side. It's synonymous with evil, or certainly the worst things that human beings can do to one another. So it's very common that actors in conflicts will weaponize the vocabulary of violence, and especially they'll weaponize the use of the term genocide because of this normative connotation. There's a second dimension, which is a legal dimension, which is that there's a UN Genocide Convention with a very specific definition of what genocide is in international law. That, as I'll talk about in just a second, that legal definition is both broad in the sense that it covers a wide range of acts, and is very specific in that it limits genocide to acts committed with a specific kind of intent. And I think that well, I'll come back to the legal definition in just a second. And then there's a third understanding, which is kind of relates to the etymology of the term and to a more common sense and sometimes scholarly understanding, which is, right, an attempt to destroy groups or an attempt to annihilate groups, full stop. And so it's a contested concept. It's a contested concept in the public sphere. It's a contested concept in the academic sphere. And it remains a powerful one, an evocative one. And so it's very common that we get these kinds of debates about whether or not a case is genocide or is not genocide because of these discrepant usages. So I'll come back to that in just a second, but just for a pause on this question of the legal framing, as some of you will know, the UN definition, the legal definition of genocide defines genocide as the intent to destroy in whole or in part an ethnic, racial, national, or religious group as such. And it lists 5 constitutive acts that will indicate that intent. And they include killing members of the group, causing serious physical and mental harm, and transferring children of one group to another, right? And one can look at what's happening, at what Russia is doing in Ukraine, and argue that each of these is taking place, and in particular, the question of the forcible transfer of children. I think where some of you will know this, but where this question often gets stuck is on this question of the so-called special intent, and whether or not there is this intent to destroy a group as such, in whole or in part. And one can infer that intent from high-level statements such as from Putin that Ukraine doesn't exist, and Ukrainian culture doesn't exist, and Ukrainian identity doesn't exist. But it often comes down to the pattern of action on the ground. And I think this is where many investigators have gotten stuck. And it's not clear that the pattern of action on the ground is toward the end of destroying the group. There are clearly efforts at depopulation. There are efforts at collective punishment, efforts at coercion, right, using violence against civilians to try to weaken Ukrainian defense and impose negative effects or negative harms in order to deter Ukrainian authorities from resisting further. But it's not clear necessarily, at least not yet, at least to my mind, that pattern of action indicates this intent to destroy. So I think the Commission of Inquiry's caution is appropriate, as are other areas when dealing with this legal question. So then the question is, does this all matter? What's at stake here? And I guess in my view, while taking seriously the importance of this question and these ongoing investigations, I think it's really important to decenter this genocide debate, right? At the end of the day, the term is very evocative, but there's often a lot of energy put into what can be a dead-end conversation about whether or not something is or is not genocide, where oftentimes the evidence can be ambiguous while the case is ongoing. Sometimes it's not, but it often is in this case. And I think what we've seen over the last 15 or 20 years is a widening of the vocabulary to, in particular, introduce the idea of mass atrocities, which encompasses genocide, but also crimes against humanity and war crimes, and to have this slightly broader category for thinking about the kinds of massive human rights violations that might be ongoing in a particular case. And I think in this case, it's kind of incontrovertible that there are war crimes. I mean, as Rachel and Nathaniel were talking about earlier, that there are war crimes and crimes against humanity, that there's been this systematic and widespread violence, deliberate violence against civilians. And I think that this is a sort of a safer and easier space on which to argue and draw attention to the mass violations of human rights that are being committed inside of Ukraine. So it's not to say that we shouldn't consider the question of whether or not genocide is happening, but it shouldn't be the main question that is being asked. And I think can often distract from other kinds of important questions, like how do you have accountability, who do you punish, the kinds of questions that Monica was raising, and so forth. The second issue that I wanted to address somewhat briefly, and this will overlap a little bit with some of the other statements that were made, is, what do we learn from this case in terms of the overall state of, the anti-atrocity regime, what I'll call the anti-atrocity regime in international politics. And I think many have read this case as saying, there is no anti-atrocity regime. It's certainly, Russia's tearing it apart, China's tearing it apart, et cetera. By contrast, some have sort of said it is an opportunity, to recognize sort of strengthening. So I think, what do we see? I think that the proximate historical context for answering that question is there has been a substantially expanded and improved anti-atrocity regime really since the late 1990s. And Nathaniel covered this a little bit. I would date that in particular to the sort of legacies of the former Yugoslavia and Rwanda. And there was a kind of ramped up system that included what we've been talking about today, forms of international criminal justice, forms of domestic transitional justice, but a whole range of other kinds of developments. These include different policy frameworks, stronger normative content or clearer normative content around anti-atrocities, a range of tools that sort of they go from documentation to sanctioning to different forms of military action and other kinds of and so forth. And I think these have been pretty significant changes in this space over the last 20 years. And I think the question is, what do we make sense? How do we interpret the status of that in light of what's happening in Ukraine? And I don't think there's necessarily a clear-cut answer to that question. What I'd like to do is put 3 points on the table for discussion, and then I will wrap up. I think the first is to say that, and this discussion really points to that, is that many of the elements of that anti-atrocity regime have been invoked and implemented in the war in Ukraine, right? So this ranges from strong and clear condemnations from leading international actors to the kinds of discussions that Rachel and Nathaniel were having about, fact-finding missions, documentation and investigations, to the UN Commission of Inquiry, to the ICC investigation, to the extensive documentation inside of Ukraine, as many of you have commented on, and the kind of international support for that documentation. There have been, as we know, extensive sanctions and so forth. So some of that, of course, is about countering aggression and countering the international war, but a lot of it has related to the atrocities. So it's not as if the anti-atrocity regime has been absent in this case. In fact, many of the tools that were developed have been deployed in quite substantial number. Now, the second, and perhaps this is a little bit more controversial, is that there has been, from my reading of the data, and I am not an expert, and I want to say there are many threats to inference here, but there have been an overall decline of violence against civilians over time. And I think that life is still hell in much of Ukraine and under the threat of constant attack. And I think there are many possible causes of that decline. But I think it's plausible that the surge of attention on the atrocities against civilians related to a kind of restraint that was being implemented in the war in Ukraine. At least I think that's a plausible hypothesis that we want to look at over time. And then lastly, for just thinking more broadly about what this case, how this case fits in sort of more global, in a more global context, I think that we have to recognize that Russia is a very particular case. It's a permanent 5 member of the United Nations with veto power. It's a very powerful state with a substantial arsenal of nuclear weapons. And so even if we were to conclude that the anti-atrocity regime was weak in this particular case, I don't know that we want to then go on to, end up saying that this is a dead zone for world politics more generally. So just to conclude, I sort of understand the Anne Applebaum sense of like, we're in this no more, we're not in a rules-based order anymore. Human rights and this kind of the kinds of things we're discussing are no longer pertinent in the world in which we live. But I don't think that that's really what the evidence says right now. I think there has been a lot of activity, whether or not it's good or bad, or what kinds of effects it will have, the kinds of questions that Monica was asking. They're absolutely right questions to ask. But I think that we, I don't think we can say that this regime is yet dead. So thank you very much.
Thank you.
Thanks.
Oh, sorry. Yeah, just thanks very much for that interesting perspective. And now Josh will kick off the Q&A.
Yeah, thanks. I wanted to thank all of you for these incredibly and important remarks here. I know I've already learned a ton in the first hour of this seminar. Before I go to the questions, I just want to again encourage our audience, if you want to put questions in the Q&A, we have a couple which I'll go to in a minute. But this is your chance. If you would like your questions to be answered, just use the Q&A on the webinar. The other thing I wanted to do, which I mistakenly forgot to do at the beginning, is thank Anton Shirkov, who is a postdoc at Harriman, who's been working with the New York City Russia Public Policy series for the last year and a half, but who put together this panel today. And so a huge thanks to Anton for all the work that went into putting this together today. And Anton, if you have a question, you should ask it. My question that I want to ask, I have a question that I want to start off by throwing to Rachel, Nathaniel, and Scott. And Monica, I have a slightly different version of it for you. So if you'll I'll get answers from the other 3 first and then come to you on this. But the question I have, and it's sort of, for Rachel and Nathaniel, it's more similar, which is when you are thinking about collecting this data, and this actually will loop to the question I'm going to ask Monica also, but when you're thinking about collecting this data, this evidence, in this particular context of interstate concerns about war crimes, about crimes from citizens of one state against another state, but as Scott noted at the end, that other state happens to be Russia. Who are you thinking about as the target audience here for the information that you are collecting? Are you collecting this for courts to use in trials that you think will actually take place? Or are you collecting this for history? And I could see either of those being the case. I could see it being super important. Or I guess, are you collecting it, as Rachel, as you sort of said at the very end of your remarks, are you collecting it even if it's not for, it's not quite the immediacy of, oh, this is going to be evidence in a trial, or the long-termness of this is so the historical record is set? Are you correcting it for that the people who have been the subject of this violence have a sense of being heard and being seen and being watched? So and then my question is, as you go about collecting this evidence, I can understand that you're doing all 3 simultaneously, but if you think one is more likely than the other, does that impact the way you go about documenting what you're doing? Do you approach the tasks that you're doing here differently if you think history is the audience as opposed to thinking courts are the audience? And Scott, when it gets around to you, maybe we'll start with Rachel and Nathaniel on it. I had the same question about this debate about genocide. Because you make this argument, which I found quite compelling, that we are getting caught up in this debate about genocide. Is that different if we're getting caught up in this debate about genocide because of a short-term concern about what does this say about court cases? Is there a court case here to be made for genocide? Or is it a different question are we less worried about getting caught up in it if what we're really trying to do is have this for history, or does it not matter in those cases? So that's what I found myself wondering about as I listened to all three of you talk about what you're doing. So we'll start with whoever of the three of you wants to jump in first. Rachel, yeah, we can just go.
Yeah, I can start. That's a really great question. So glad you asked it. Well, look, I mean, who are we doing this for? Ultimately, we're doing it for justice. But at the same time, I think it's, important to have a bit of hubris, but and also to stick to the facts. Human Rights Watch, we and other organizations like ours, we are not police investigators, right? We're a non-governmental, we're a human rights organization, and we're documenting human rights violations. But we are, we're not criminal investigators, our working methodology is very different from from a working methodology of criminal investigators. We're not like we obviously we seek to establish the facts, and we use as many tools as we can to establish the facts. But I would never expect a court of law to use in an unvarnished way a Human Rights Watch report as a standing piece of evidence, right? So, but our hope is that our reporting will contribute to decisions that either state or interstate investigative bodies, decisions that they would make about which cases to prioritize, right? Because we're facing a prioritization challenge, but so is the International Criminal Court, and so are those states, and there are more than a dozen of them that are engaged in conducting investigations and under the principle of universal jurisdiction. So in other words, they can prosecute and try a case of an international human rights violation, an international crime, I should say, even if it didn't take place in their territory, and even if the victim is not, one of their nationals. So, there's multiple. There's so much that there have been so many violations, so many potential crimes committed in Ukraine. These bodies are also, looking to prioritize. So we hope, we hope that our information, our reporting helps to, helps them to prioritize. And, we also hope to contribute in other ways by, when we interview people who are witnesses or who are victims, sometimes, often we'll ask them if they want to be contacted by other, investigative agencies, and if they do, then we can pass that information on. And there are other modes of communication and collaboration.
Nathaniel?
So I'm going to give a simple answer and then a complex one. And my simple answer is going to be the exact opposite of what Rachel said. What we are doing here is at its heart forensic and to a criminal investigative standard, with the specific focus in everything we do on forensic chain of custody for admissibility in trial. So that's the headline. And that is, as someone who has been trained by analog forensic medical legal investigators, Bill Haglund, Stefan Schmidt, in terms of doing mass grave forensics on the ground. I come from a school of human rights investigations that is less about witness testimony and more about physical forensic evidence in a context most drawn from ballistics examination and physical medical examiner level investigation of physical remains. And so everything we do is really based on a standard where we are expecting every piece we collect and every finding we make to have to go into trial and stand up to that scrutiny. So that's the simple answer. The complex part is that we are releasing public reports. And so the public reports end up being used by a variety of actors for advocacy, for policy, for accountability. And what you see on the Conflict Observatory website is literally the tip of the iceberg, that underneath all that, there is an infrastructure, a personnel capability, and really data logging and data storage infrastructure that the public never sees. That really at the back of the shop is in fact the factory floor, and the factory floor is really about a forensic capability. And what is unique about Ukraine is that it is to look at what the future looks like, look at the present in terms of where Ukraine is now, that we're dealing with digital data deluge, where in places like Sudan, we have a dearth of digital evidence. And so it's an entirely different type of investigation, where in Ukraine, we're drinking from the fire hose, where the evidentiary challenge is the overload. And so a lot of what's happening technically now is new, not in the types of investigations we're doing, but the absolute Gaussian, and I can use that term mathematically correctly here, Gaussian proportions of data that we're dealing with that's probative, potential evidence of a crime. And so when we look back on this period, it will have been, on the technical side, a story of forensic challenge of trying to put a harness on this data horse here that's unprecedented in terms of its granularity and volume. Over.
Scott?
Yeah, I guess thanks for the question. And it was really great to listen to the previous answers. I mean, so I think what I would say is that the language of violence gets wrapped into a kind of information war, which is about the legitimacy of different sides of in this conflict. And genocide is often part of that sort of information war. The term genocide is often in part of that information war. And I think that can create an unfortunate circumstance where you have to recognize that genocide is occurring in order to indicate your sympathy with one side or another, and to indicate a certain level of concern and a certain level of human rights violations. And I think that's a kind of bad place to end up, in the sense that I think we can acknowledge huge violations of human rights, mass atrocities, and still leave open the question, like, is it genocide or is it not, but not focus on, genocide is the litmus test for arguing that, atrocious violations of human rights have occurred. And that was sort of in some ways the point I'm making. I hope that answers your question.
Great. Thanks for all three of you. For Monica, taking this question in just a slightly different way, right? So Monica is the author of this book, Skeletons from the Closet, which I've taught to my students. It's a fantastic book. I recommend it to all of you. But my takeaway from the questions of transitional justice in that book are that they're about domestic regimes. So the regime is overthrown, and now it's what happens on transitional justice, and does transitional justice how does transitional justice interact with the stability of the regime that follows that? How then, for those of us who've read your work, how then do we think about the insights from that in this context, this interstate context? And I guess the question that and this was sort of what motivated my question to the other three of you, which is, there's this tremendous work being done to document everything that's going on. And Nathaniel, you're saying, very much so with a point of view of forensic evidence that could be introduced in court cases. On the other hand, at this point in time, those of us who've watched Putin for many years, I mean, look, it always could be the turning moment. We've talked about the turning moment many times, but it never seems to be, right? And, with the context of the ability to hold any Russians accountable for what is happening in Ukraine seems to be context dependent on the regime in Russia cooperating with this, which doesn't seem to have any interest, this current regime, in doing that at all. So how does that affect these questions of when there can be attempts to enforce accountability. How do we think about the accountability mechanism here when we have this interstate dimension to it as opposed to the transition dimension to it?
Thanks. And this is also an opportunity to sort of clarify some of the things I had raised with international transitional justice. So first of all, yes, domestic transitional justice is only possible after regime change in Russia. And, you know, we don't know when or how that is going to happen. I really can't envision any even like related to the Putin regime collaborating with international organizations for accountability. But I think the danger is this, that once we cede to international organizations, and such as international courts, international tribunals, whether ad hoc or not, the role of holding accountable authors of, you know, a whole variety of war crimes, whether they be genocidal, or other, there's this temptation to rely on those organizations permanently because the domestic system is overburdened, because it's in its infancy, because it's rebuilding, because it's retraining, and so on. So I think what's very important in starting holding accountable leaders for crimes committed abroad is this notion that, you know, that there's a limited time frame for these tools. And you know, and I'm also going to you know, just point out that it's very hard to demarcate international crimes from domestic crimes, right? Because you know, the scale of atrocities Putin has committed on its own citizens has drastically increased from the start of the war. There's and I know that the efforts of documenting that are not as thorough as the efforts documenting crimes committed in Ukraine. So, you know, as much as we would like to think that there's like an easy way to organize, you know, crimes committed in Ukraine and crimes committed in Russia by the same person in the name of war effort, that's just not going to be possible. So I think at the end of the day, a huge responsibility of holding to account you know, Putin and those who are following his orders. I cannot stress more how important it is to hold accountable also the rank and file, those who actually committed the war crimes, sometimes even without the explicit permission of their supervisors, to account. How important it is to acknowledge that that is also Russia's responsibility. And you know, we have precedents for this in the past, right? So the effort, the successful effort at denazification, because looking at Germany today, we have to admit that from the point of view of long-term democratic stability, that was a successful effort. It happened, you know, it was started by the Nuremberg trials, but it happened thanks to denazification efforts that were carried out for many, many years later, and domestically. And I think that, you know, the challenge for Russia, once, you know, it has abandoned this regime, is going to be a thorough reckoning with its past, and a reckoning that will acknowledge that, you know, that under the Putin regime, there were those who were helping him, but there were also those who were opposing him. And it's going to be in the hands of those agents to I think bring the transitional justice project to a conclusion. Because I was just, you know, I wanted to just return to what Rachel was saying. I think justice is not the ultimate goal. I think the ultimate goal is peace and democratic stability. And I always see justice as just instrumental to that. There have been instances in the past where the pursuit of justice for no matter what has actually undermined the goals of peace and democratic stability. So I just wanted to, you know, put out there that my normative priorities are there and not just justice.
Okay, thank you. My question was going to be about temporality and timing. So Monica, you were just, you know, highlighting one of the important aspects of that question with regard to domestic processes. So I guess to sharpen, I guess I was just thinking, you know, it took so long for some of the war criminals in former Yugoslavia to be brought to justice through the ICTY process, you know, more than 10 years later. And I'm just wondering, I guess I could sharpen my question about the kind of longue durée of these this problem by possibly asking Scott whether, something has been learned in terms of, or whether you think about the strengthening of the anti-atrocity regime as a result of the slow pace of previous tribunals, and whether the present forms of discussion about a particular case, like the Ukraine case, might have an effect on the kind of the timing or the long term, putting us, maybe bracketing for a second what's going on domestically, the kind of response of the international community, whether that might be affected by the debate of the debate about the anti-atrocity regime in terms of the slow timing and how that, was either a problem, what we learned from Yugoslavia. So yeah, it's not a very sharp question. I just kind of wanted to think about this issue of the long span of time over which these issues play out.
Yeah, I mean, it's a great question, and I don't know that there's necessarily a clear answer to it. I think what I would observe is that, at the international level, and Nathaniel's work and Rachel's work is evidence to this, like there is a sophistication of the tools in the international community with regard to documentation, to war crimes, to investigations, to the forensics, to the data work, etc. But I would say, to Monica's points, the domestic effects of those of that justice regime is ambiguous at best in my reading of it. And so even in the former Yugoslavia, where you have, I mean, ICTY, of all the international criminal courts that have existed, period, I would say, has been among the most even-handed, and has been, I think has done exemplary work in different ways, has produced tremendous polarization on the ground inside the space of the former Yugoslavia. And Bosnia remains, as my reading, again, I'm not any expert of Eastern Europe, remains as divided as ever. And so I don't know that necessarily that even over time, right, that we are now close to 30 years, past the wars of the 90s, and certainly, decades after some of the landmark trials, that you can say that it's had the effect of producing democratic stability, or of a stronger human rights culture, or of any kind of, something related to reconciliation or a common understanding of the past, which I think can be essential. And so I guess what I would just say, and then I'll say maybe draw up to cases I know a little bit better, in the sub-Saharan African context, which is to say, like, justice is very politicized, and in the effects, the domestic effects of justice are often highly political. And so if we're thinking about our outcomes as democracy, as stability, as a stronger commitment to human rights at the domestic level, as some form of social repair at the domestic level, often those outcomes are very dependent, I think, on the domestic space more so than the international space. I mean, I think as Monica points were suggesting. Well, let me pause there. I won't go into an Africa discussion. Thanks. Yeah.
Nathaniel?
Yeah, I think this is such an important question. And so I'm not going to disagree with Scott. I'm going to offer a different perspective. It may sound like disagreement, but it's not. It's just a technical practitioner's perspective on the time question. If we think about the average individual murder in a U.S. court, it takes 18 months to 3 years to close that out. And that's including appeals. And that's a rough estimate. In terms of the 10 years on ICTY, you have to understand that in that initial period, like with the antemortem database identifications in Srebrenica, the actual evidentiary collection process to get ready for trial, to even get ready for trial, was 3 years. And then the whole process of going to trial and appeals, and then the NATO effort to identify and capture the individuals, from my perspective, and this may be the fact that I've been doing this 24, almost 25 years now, 10 years as a closeout is quick, right? Like I heard that and I was like, 10 years, I'll take 10 years. I mean, we've been on Ukraine right now. Almost half, as long as U.S. involvement in World War II. My team, right? And we've been straight with almost no vacation, no break in like Battle of Britain level. We did, 240 bomb damage assessments in the first 2.5 weeks of the war, right? And we're looking at a level of speed chess right now, which is something I worry about a lot, that we're moving at a collection speed, which frankly would never, even in like domestic US police department, we'd never be moving at this speed, right? And so we went from evidence to indictment in 1 month on ICC with the children's case. And it's like, now I even want us to slow down, because there's been this conflation of the political with the evidentiary, where the accountability process in Ukraine and the political discussion around it, the technical element and the political element has become conjoined in a way which could be dangerous for investigations, in the sense that some of these processes take a lot of time, and moving too fast. A good forensic investigation is like a souffle. You can't take it out too early. You can't take it out at the wrong time, or it's going to deflate. And so I just want to say here, from speaking for the technical folks in the room, that like 10 years on just Srebrenica, like 10,000 individual remains. Okay, I get that, and so we have to be very careful here on political timeline in the actual timeline to bring the complexity of these cases, not even including appeal. Over.
And one question that we've gotten a couple variations on in the chat, is how what is happening right now in the work that you all are doing on documenting what is happening in Ukraine likely to be impacted by the events that we see developing today in Israel and in Gaza. Is this the kind of thing where these are totally separate? I mean, Nathaniel, you're talking here about the politicization of issues, right? Like, does this complicate things? Does this put more strains on resources, Rachel? Or do you look at this as these are just sort of totally separate operations, and this is the way that, people in your field work in this way? This happens, they work on different things at different times, and it's not going to be much of an issue. But just given that we're having this seminar today, I thought I might ask that.
Well, there are two ways of answering that question. One, just at a practical level, resources are never unlimited. And whether it's the level of an organization, of an NGO, or if it's at the level of the International Criminal Court or anywhere, people, that obviously that's the situation in Israel-Palestine is quite dire. But at the same time, but there's another way to answer that question, and it touches in another set of issues, and that's there have been a fair number of grievances about the rapidity with which the international community responded with such a strong justice impulse in Ukraine. There was an unprecedented outpouring for justice in Ukraine, which we were of course thrilled to see. Outpouring of support, outpouring of resources, and then there was the rapidity with that Nathaniel was talking about, really at light speed with an ICC arrest warrant. Whereas in other situations haven't had the same kind of attention and resources. And I think when justice isn't served well in other places in the world where there are serious, where there are atrocity crimes, then it's not going to be well served in many places, because the structures for international justice won't be, if they don't have broad support, they will, they'll suffer. So these claims of these, grievances that have been articulated about Ukraine getting, about there being double standards among the international community because they acted so fast and so extensively on Ukraine, but action on Israel-Palestine took so long. I think it's important to listen to those concerns, but I think the answer is not to make Ukraine suffer, pull resources away from Ukraine. The answer is to, just make sure that there are, that there's a sufficient investment in justice all around. So it's just to say, but we live in the world we live in, and resources are always limited.
Yeah, I think what you just said, Rachel, is like the most important thing that has to be said in this conversation is that Ukraine is not happening in a vacuum. And my team and I have been one of the biggest beneficiaries of the resources brought to bear on Ukraine. And I've personally been one of the loudest critics of really the disparities in investment that have happened. And that doesn't mean pull resources from Ukraine. It means create standing capacity, just as Rachel was saying, both for structures and for the investigative component, and get those in the right proportions. I mean, I'm working a mass grave in Kadugli, Sudan from 2011, right? Which, thousands of people, one of the largest, and another mass grave in Afghanistan, two of the largest single massacre incidents since Srebrenica. They're never going to see trial, and they're never going to see full forensic investigation. They're never going to see investment. And so on one hand, we have, Ukraine here, where we're driving the Maserati from a capability perspective. And then, we're on a Schwinn bike or a BMX, metaphorically, or maybe a scooter in the case of other longstanding, basically international cold cases, right? And they're not cold cases because we don't have evidence or we don't know who did it. It's cold cases due to lack of resources, mandate, and political will. And so to hit the critical question here on, what's happened with Israel-Palestine, how does that affect things? I don't know fully yet, but it will, and we're going to find out. But we do know that we international, and this is not said as a political thing, just technical fact, but comes from political factors, is that international justice and international investigative capabilities really are technical reflections of political will, and so that's the fact. And so we have to have political will to change that. And what that means is moving from incidental deployments to broader, stronger standing capacity, and that's why the ICC was created. But the ICC alone is not enough to solve that problem.
Okay, we're my apologies. I'm having some internet issues here, but we're at time right now. I want to give Monica and Scott a chance to respond. They both have their hands raised, but if I can ask both of you guys to just be sort of on the brief side, because again, I want to be sensitive of everyone's time, but I'll give you two the last word. So Scott and then Monica.
So just 30 seconds. It's like, in addition to the question of discrepancy of resources, there's also the question of the perception of the politicization of international justice. And so if all the investigations we've been talking about are seen for Ukraine are seen as the outcome of an ideological sympathy with the West, that is, this is the handmaiden of the West, of the power of the West, then I think that ultimately undermines the whole international justice prospect. And I think that will be at risk as well in the war in Israel and Gaza. That is, if justice is deployed as the perception of it as the handmaiden of the West, that is just against Hamas, I think that will ultimately in the long run, weaken what we've been talking about today.
And I will just say that I think the conflict basically poses challenges for the consensus of what kind of crimes are those that the international community should focus on when holding perpetrators accountable, because suddenly I think this conflict has invited more scrutiny about saying that yes, these crimes are prosecutable and those others aren't. And the only other thing I would say from as a comment to Nathaniel's amazing work is I think that precisely the goal of working like graves from more than a decade ago, even knowing that not much judicial accountability is going to happen right now. I think this exactly shows that this is material for truth commissions, which have perhaps the greatest chance of permeating, the new societies that are being created, and and acknowledging victims and giving them a chance to relate to these truths. So again, just ending on a note, like beyond the criminal chambers, there is room for transitional justice.
Well, I think we're going to have to call it there. This has been a really stimulating and fascinating discussion, and I can't thank each of you enough for participating and sharing your expertise with us today. And on behalf of Jordan Center at NYU and Harriman Institute at Columbia University, thank you, and thanks to everyone for coming. And tune in again for more of our panels and talks. Thank you.
Thank you.
Thanks, everyone.
Thanks.